Oh, thank you. We're on the second half of Section 10. We started Section 10 last time. And we've got a couple rules that I want you to take a look at just quickly. And I'm not going to go into the intricacies of them, but they're Rule 5 and 6. And generally, we don't do much with it. And the only time you really start to do anything with it is when you have a case and you've actually got to try and figure out how much time you have to respond, who you serve, and the rest with your information. So Rule 5, if you looked at it, deals with serving and filing pleadings and other papers. If someone obviously doesn't appear, and you've got multiple defendants, at some point they're in default and they don't have to be served any further. But once someone is represented by an attorney, Rule 5 governs that from there on out, that attorney would receive notice to the party. So you don't continue to serve the party once the attorney has filed an appearance. And any pleading constitutes an appearance in the case as well. Rule 6, and when we start to worry about Rule 6 is when we're trying to figure out how do we compute how much time we have to respond to a given pleading, whether it's a motion to dismiss or motion for summary judgment or whatever. And in the real world, it becomes important because you may make a difference as to whether you're working the weekend or not. Reporter asked me the other day, she said, how come you guys always serve things on Friday afternoons with the court and the other side? And it's unfortunate, but that's what we tend to do, is use the week to get what we need done, and then we end up serving them on Fridays. And depending on the type of motion, that weekend may count as days included in the time for your response and the like. So some people do it as a tactical matter. I'd like to think it deals more with trying to get the work out by the end of the week. But there are many attorneys that traditionally will wait till Friday to file a pleading, and then the question is, how much do I have? 7 days? Do I have 10 days? Do I count the weekends and the like? And so when you have this problem, you need to look at Rule 6. And Rule 6 talks about how those days are actually computed with respect to having to respond, what holidays would be counted within it, and how you would then compute that time period. Some of this is also governed by what we call local rules in the federal court, but it's also governed in Massachusetts when we talk about serving pleadings and the like. If we're in Superior Court, it's governed by a Superior Court Rule 9A process. So in addition to the regular rules of procedure that you have to be aware of and we've exposed you to from time to time, you also need to recognize that virtually every court has what we call local rules of some court that you have to comply with respect to service and computation of time and what type of response is permitted and the like. And the key to all of this is that if you do not respond timely, the likelihood is you have forfeited your ability to object to whatever it is the other side is looking for. And in some cases, those motions will be automatically allowed and the like. So you've got to be careful, and you've got to respond timely, and you have to be professional. And then at some point, you may need to ask for an extension. Generally, you would ask the other side first, but it also, you have to be reasonable about it, and you really need to understand what it is that you need to do in that period. Sometimes you're going to have trial, you're going to have press of other work and the like, and so there may be a legitimate reason for your need for additional time. It's one thing if you ask me for a couple of weeks, maybe even 30 days, depending on what the motion is. But if you're looking for 6 months, the likelihood is the answer is no. And I think there's a certain obligation to each other as members of the profession to be reasonable about it and extend a professional courtesy with respect to an extension of time. For instance, responding to a motion for summary judgment, you might need counter affidavits, you might need to go through the record to a much greater extent. That may take a lot longer or it may take at least up to 30 days to be able to do a thorough response. And so you may need to request an extension. And if the other side won't give it, then I'm going to go to court and request it. And oftentimes, certainly if the request is not unreasonable, the court is likely to grant it. But this does and can become a source of some tension between attorneys, because there will be some people that will want an extension all the time. And you've got to remember, your client is interested in getting this matter to trial as quickly as possible. And so it's one thing to give a short, reasonable extension. It's another thing to postpone it to the extent where the client now feels that their interests are secondary to your, what as you see it, your professional obligations to be courteous and the like. So there's to some extent a balance there. But it starts with you knowing how much time you have to respond to a given motion. And I know sometimes lawyers, especially new lawyers, think, well, I'll just call the clerk and they'll tell me. The fact is you can't necessarily rely on the clerk to give you accurate information, or even if the clerk gives you information that you then proceed upon, that doesn't mean that you as the lawyer shouldn't have understood what the rule was, how much time you have to respond, and have done it appropriately. Blaming the clerk when the judge says you're late is not likely to be a successful argument. You're the professional. You're the one that needs to make sure your responses are timely. And I think at the minimum, as lawyers, that is your professional obligation. And none of the garbage that we sometimes hear about, this or that came up, my computer crashed. If you wait till the last minute, you should expect that you're going to have problems. And I think attorneys not meeting deadlines is a problem that is likely for a number of attorneys to get them in trouble pretty quickly with the Board of Bar Overseers. And if the Board of Bar Overseers feel that you have been professionally negligent, you're not likely to be a lawyer for long. So all of this comes into play. It starts with knowing what you have to do and when, and then there will be weekends where you're going to have to work in order to get it done. That's part of the job that we sign up for. So take a look at Rule 5 and 6, but you're really going to take a look at it when the question is, do I have to work the next Saturday? Do I have to work Saturday and Sunday in order to get this done in time? And the answer might be yes, might be no. So you might want to take a harder look at Rule 5 and 6 and figure out whether you have 2 full weeks or not to be able to do this. Let's talk about Mark versus Kahn. We talked about Burke versus Revo last time. What does he want? What do they want to do in Mark versus Kahn? Mark versus Kahn.
She wants to register her kids in school with her new husband's last name.
So she wants to change the name of my children.
Without his consent.
Huh? Without his consent. Well, what do you think of that? No? I'm sorry, go ahead. Not in this case? Or not in any case?
Not in this case.
Why not in this case, or why in other cases?
Well, why not in other cases? Because sometimes some parents do abandon their child, their babies or their little kids. They never show up in their life again. The mom, remarries, wants to continue. That parent might adopt him or give him his name. It's fine. He has a father.
If the parent hasn't taken an active role.
In this case, he's a good dad. He's in the kid's life. He pays child support, and she just wants to switch the kid's last name without his consent to satisfy her husband's wishes.
Well, to satisfy the husband or the children? Go ahead, Charlie.
I think they allow the name change when the purpose behind it is it's for the child's best interest. So when the motive is the child's best interest, the courts are more likely to change the last name. Whereas if there's an improper purpose for changing the name, they're less likely to grant that.
So all she has to say is that there's a proper purpose. It's not for spite. Who's going to go into court and say, no, I'm changing the names because of spite?
Well, you'd have to look at the surrounding evidence.
Well, in these blended families, one wouldn't take a very clever lawyer to make an argument that they'd all like to be brothers and sisters and go to school under the same name, right? So my kids become Condarellis instead of coins? Even though I'm paying support? I mean, is Charlie right? So even though I'm paying support, even though I'm an active parent, the court could determine it's in the best interest of these children to have a name other than the one I gave them? No, they couldn't? Charlie says they could.
What would be a good reason?
Huh?
What would be a good reason?
We're a blended family now. The kids are relatively young, and everyone's saying, well, how come your coin and your brother is whatever?
He's not my father.
Huh?
He's not my father.
What'd you say?
He's not my father. Like, their dad isn't my father. You have.
Well, but you know, I mean,
in their life, especially.
No, it's not.
but in some situations, they do see the new parent, the one they live with, on a more regular basis as likely their parent. No?
Well, this case took place in a time when that was more of a...
So is that what it is, 56, so now?
Yeah.
So this wouldn't happen anymore? Because an ex-wife would never be sufficiently spiteful that she would want to change the name of my children. Is that what you're saying?
You're so jaded.
I did some of these cases early on. So yes, I am a little jaded by some of the intent on some of these. Yes, I am.
I agree. I think, I don't know.
Well, doesn't
Go ahead.
the father has a say, right? He has to be notified that such a motion has been put in front of the court. So he has to come in and say, no, these are my children. I don't agree to that name change.
But even over his opposition, as I understand it, the court could determine that it would be best for the children to have a name other than my name. No, I mean,
Does that relinquish him from child support?
the change of name is not, well, let's talk, the change of name is not going to relinquish you from child support, right? Adoption would, an adoption will terminate, a change of name will not. So,
I think when you terminate your parental rights, like you consent to it, the mom can.
but I'm not terminating my parental right. I'm not, the court isn't terminating my parental rights or my obligations. They're simply saying, your children now have a different last name because it's in their best interest.
It looks the same to me.
Huh?
It looks the same to me.
Well, I don't know what you mean. What do you mean it looks the same? Because it's not, because I'm still paying a large amount of money at the end of each month, and now they don't even have my name anymore.
Yeah.
And I think in part she did it for spite.
That sounds crazy.
What? No, but they could, go ahead, what?
Is there a relationship between the children and the father?
Yeah,
Yes.
there is.
And she still wants to change the children's names?
Well, but my guess is, just so we understand how this likely percolates up, it's, I don't want to change them. The children keep asking me, we should all be the Brady Bunch. So it would be nicer if we all had the same names. And frankly, my guess is it would build team unity a little bit, right? It wouldn't take much to make that argument.
Couldn't the dad go to court and says, I object because, well, look at our history, we got divorced, well, make sure they're going to divorce this person too.
What if
You're going to keep changing names every time you marry somebody else.
That's going to be a tough sell, Emerald.
Change my baby's name.
Well, but so, how is the court going to separate out? Go ahead.
Well, when you look at the best interest, there's different things that they use or evaluate. One of them would be that they could ask the children. They'd have to be of an age of consent. In this case, that wasn't the case.
What is the age where the children would get more of a say at the table?
18.
No, it's not going to be 18.
Well,
Maybe 10?
No.
It didn't say specific.
Okay, at the time of the hearing below, their ages were 13 and 10 respectively. So these children were 13 and 10. And the provisions in the agreement were support in education. And the court says, well, we're not going to worry about that because nothing changes with respect to that. By the way, the obligation of support and your ability to support and your visitation are separate items as well. We tend to say, well, if they're supporting them, they get to visit. There will be times where a party can't support them, but that shouldn't affect the visitation, although that can be used to some extent as an argument, but it's not a sufficient argument. They really should be, and the court will generally treat them as separate. So at what age do you think you would give them a greater say at the table? Because by 18, if they were 18, they could change the name on their own, right? Anyone can change their name. Actually, in Massachusetts, anyone can use any name they choose as long as it's not for an illegal purpose, even without a court-authorized name change. Beyond that, you can have the probate court, you can petition the probate court to change your name. I've done some of those. That always seemed odd to me why you would want to change your name, but there are clients that actually want a different name other than what they were given. And then the process, you have to publish it and the like, so it's not that inexpensive anymore because of the publication aspect of it. But you can change a name, and the court regularly approves change of names if someone wants to actually go through the court process. And that's on page 520, by the way. It says, previously this court has said that a common law person could change his name at will without resort to legal proceedings by merely adopting another name, provided that this was done for an honest purpose. So now we can also do it by statute as well. So tell me, it sounds like you're saying you would never authorize a change of name, but there must be, if the father is involved, there must be circumstances where that would make sense, no? Go ahead.
Well, she didn't actually try to change their names, right? She just registered them and was going ahead and using these other names, and then he tried to get an injunction to stop it.
Well, but again, because you don't need a court approval to change a name in Massachusetts, you have the ability to, as long as it's not for an illegal purpose, you have the ability to use whatever name you want. So, right, she's now registering them as, with her new husband's surname, and saying, and the ex-husband is the one complaining. Go ahead.
Huge deal. You go to school to pick them up, and you got a different name now, especially today, they're not going to release them.
So,
Same thing happened to moms that got divorced though.
Yeah, but there'd be a legal change. I'm just saying, if you put a name in, you're just starting to register your kids with a different name, and now the father goes to pick them up. They're like, no.
Who are you?
Yeah, exactly.
Yeah, but they would know. I mean, if you have the same name, so if your last name's common, like Jones, you're gonna let any Mr. Jones walk in, or
No,
pick up the
you got
kid.
an ID.
Well, yeah, but what if they have the same last name? You know what I mean? It's they're gonna know who the parents of the kid are.
No, they're not. Really? With like 1,000 kids in a school?
Well, I mean, so same last name, they must have something to check. They're not just, you can go pick up any kid right now just because you got the same last name as them. You know
I
what I mean?
went to pick up my brother, and they just asked for an ID, and I showed Lucia, and they said, okay, we'll call him down. They called him right down. I'm sure, depending on the age, you'd have a kid that would say, who's that? But if the kid didn't speak up and you have the same name, you're a lot more likely to be able to get away with that kid.
They just
It's just the way it
grandfather
is.
get the wrong grandkid. And he took him home. He didn't even know to take the kid home.
Yeah, my dad forgot.
Are you comfortable that the court actually could approve a change in name over the a parent who is supporting the child and is an active role in that child's life? But the court could do so if they determine somehow it was in the best interest of the child, right?
I don't see how a name is in the best interest of the child, it's just a name. Like, I don't see how there's any gain to that.
Well,
Especially if the father's no
it's
custody,
the
you know what I
active
mean?
role. When the father has an active role in that child's life, it's it's less likely that the court will allow the name change. They gave 3 instances where the name change would be in the best interest, and it's when there's no active role. It's when they, 1, completely abandon the child, 2, indifferent to the child's welfare, or 3, serious misconduct which causes embarrassment. So when you say active role, they're most likely not going to meet these 3 criteria. So
And under those 3, I don't think most of us would have a problem with saying that it may well be in the best interest of the child to create a bond with someone other than obviously they don't seem to have much of a bond, at least in the first 2. And the third, may well be a source of great embarrassment and humiliation to the child, so the fact is that may be in the best interest of the child. Would you limit it to those circumstances?
Issue number 3, what if somebody gets arrested for, drunk and disorderly one time?
How about indecent assault and battery?
This is serious.
It's serious.
Yeah, what if your name's Sandusky?
Well, that's different.
Well, it is, right? And that's, what?
The Sandusky kids, I think.
I think they did change the name, right? And I think you're right. It would depend on the criminal charges. It would depend on the level of publicity attached to it. But those are going to be the rare circumstances. Because beyond that, you could see this being used for spite, right?
Oh, yeah.
But what if a spouse is out of work, so I can't support? I try, I can't. But I still want to visit, I still want to be active.
Doesn't matter.
Doesn't matter what.
If that's your kid, that's your kid. I mean, there needs to be, like the court said, a compelling reason that goes against the child's best interest.
And you were thinking, at least in part, we're talking 1956, 2014, we have a lot more blended families and people with different names and all the rest of it. It's not the stigma that she tried, that at least they alleged was attached in part in this case, right? I mean, it's sort of the way we are.
I enjoyed the phone call, reading about the phone call between the two fathers.
Tell me, go ahead, why?
The new father gave well, I've talked to my lawyer and he said that's the way it is, so you have to deal with it, basically. So, they didn't really go about the best way of trying to change the name in a proper way.
That's another thing. Who is he to tell the dad of the children, like, no, I'm giving your child my last name?
Well, he's the one they're living with
He's
now.
just standing over and sunning him at that point.
I know. That's asking for it indirectly.
Well, but I mean, I think, we're sitting here in a classroom and it's easier just to not figure that. Because I wanted to respond to Charlie's point before it does get lost. It always did amaze me how people were more than willing to throw ridiculous sums of money at lawyers to solve a lot of the who's going to pick them up at soccer on Friday afternoon and you know what that bastard did today, then sort of address it, because for people who get divorced and have young children, they've got the next 15 years together at any rate. And it doesn't make sense to spend $200, $300, $400 an hour on us to be running in and out of court, because it gets ridiculously expensive. The problem is, in a lot of cases, that they can't communicate, they can't work these issues out, and you get a situation like this, they both then get their backs up and say, oh, we'll see about this. And now, I mean, this went all the way to the Supreme Court, right? Yeah, this is a Supreme Court case over whether they could change the name and whether that would be in the best interest of the child. And the point to take out of that part of the language is that's going to govern what the court does in the probate court in virtually every case, right? What's in the best interest of the child? And if you think about that standard, then that gives the court an awful lot of discretion as to what they see as potentially in the best interest of the child and what they can do. And so the fact is that when we think about that, it gives the court, well, some would argue it gives the court too much power. Let's take a look at Knighton versus Knighton. What are you saying?
I enjoyed some of the verdict.
Oh, yeah, the language was good in Knighton, wasn't it? So what does she want?
Her husband to love her.
She wants her husband to love her.
Or
or to not love anyone else. No, right? More importantly, so
I know.
And at the same time, keep the house even if he doesn't love her.
Even if he doesn't, she
Still
needs,
wants the house.
she needs a place to live and the like. So she files suit seeking an injunction, and the injunction is concerning her husband, who was having an affair with Mrs. Meadows. She confronted him with these facts. He readily and fully admitted them to be true. They made every effort to assist the husband in breaking away from the bonds and ties by which Miss Meadows held him, but without avail. She's just a very powerful woman.
The subtle entanglement of her charms.
It makes it sound like he's in prison or something.
So she goes to court. As Charlie says, she's still occupying the home. He's given her $100 a month, and he's employed, and so she wants both maintenance and support, as well as an injunction against Miss Meadows, enjoining her from receiving support, money, gift, presents, or others things of value from him, and from visiting with him, associating with him, meeting with him, having him visit her in her home, riding with her, or otherwise associating with him in any way. Is she going to be able to get the court to issue this injunction? No. Forcing him back, as one of you said, to love her. It says, here the language says, this may be styled a bill in equity by a married woman to enjoin another woman from alienating the affections of her complainant's husband. Equity won't enjoin this? Because adultery is a crime. It's still a crime in Massachusetts as well. Some states have abolished it. Massachusetts has not abolished it. It says here, equity won't enjoin the commission of a crime. Why not?
It's already illegal.
It's already illegal, right? If there is a remedy, when we talk about no adequate remedy at law, there is a remedy for adultery, and it's a criminal prosecution. The problem would be trying to get a DA to bring a criminal prosecution for adultery these days would be very, very difficult. It's rare. There was one probably about 5 years ago that was reasonably well publicized, but they just, for the most part, they don't. And again, this is one of these situations that sometimes arises during a divorce or some type of probate action where you may want the court to get involved to a more significant extent, or the DA's office, but they're not likely to get involved in civil litigants' affairs, for lack of a better word, under those circumstances. The fact is, she is not going to be able to get this injunction because equity won't enjoin the commission of a crime. But I've got a question for you in regard to the best interests of the child then. So during the pendency of a divorce action, I'm husband or wife. It makes no difference which one you want to be. I don't want my children living with my soon-to-be ex-spouse and her new live-in partner. Can I get an order from the probate court saying no overnight house guests?
What's the reason?
I think it's emotionally damaging for those children to have to deal with this situation during the divorce.
She'd have to be like an alcoholic or something like that.
Yeah.
Why?
Something like that, like alcohol around the children, some kind of bad
It
influence.
has to be a bad influence.
Or like abusive or something.
You don't think it's potentially psychologically unsettling to the child?
But once the divorce is final.
No, but there's no, I said this is during the pendency of the divorce. Papers were filed. I don't mind the kids going there to visit. I don't want your boyfriend there.
It could be.
I don't want, you know what, I'll even go further. I don't want you having sex in that house with those kids present.
I mean, you shouldn't do that anyways.
I wasn't saying in front of the kids.
Can't be in the same room.
Okay, but so then Jonathan, I shouldn't need a court order to do it, but then can I? I mean, if the court, in the probate court, is governed by what's in the best interest of the child, children going through a divorce like this, parents recently separated, it must be complicated enough to try and figure out what's going on, much less to have, who pointed out the last time? You did, right? Who is new dad to be telling biological dad, they got my name now, right? We don't need strange. Okay, so it's one thing where that person has already married the spouse. Another thing to have someone else dictating orders to my children who isn't married to that partner, can't be married to the partner. Frankly, it would appear that they're committing adultery. So now my children are witnessing criminal activity in that house. That's what it is. That's what it is in Massachusetts.
Yeah, but now you can't enjoy it just because it's already a crime.
Well, but all I want to enjoin is this improper influence on my children during the pendency of the divorce. I don't want any overnight house guests while my children are present. None of you saying I can get that order?
I feel like
Huh?
I mean, during the pendency of the
During the pendency of the
not
divorce.
after, I feel like you could probably get away with that.
What about that? During the pendency. I'll deal with after.
Yeah, I think that would be
Essentially, you're still married,
reasonable.
so-
Yeah.
How do you
that would
enforce
be
it?
reasonable.
Maybe enforce it.
Well,
Your brother wants
you would enforce it. We're going to go. You would enforce it by if there's an overnight house guest, then it's contempt.
What if she gets a restraining order? How are you gonna know?
I don't know. What do you mean?
Well, let's say, you got an injunction.
Oh, I'd send a
She
private
gets
detective.
restraining
Oh,
order.
and kids don't talk.
You're right.
Are you,
I think that'd be a
Uncle Dave stayed over the other night too.
just have,
Uncle.
Who's Uncle Dave?
Exactly.
So I can get that order because I thought.
No, I don't think so.
Well, but I thought you just told me that what's in the best interest of the child is what's going to govern the probate court's orders here. It must be psychologically difficult for children, young children, even probably teenagers, to go through this process, and now to have others in that mix has to further complicate it, at least during the pendency of the divorce.
If that was such a worry, though, why would you even put in the visitation right that it'd be overnight? Like, wouldn't you just keep that out and keep it to go do something for the day and then they come home to their own beds?
Well, I could do that.
If it was that big of a worry, rather than trying to regulate what the father's doing?
Well, except father or mother wants the children for 3 or 4 days. You want to split the week in essence. So, but so we can split the week, but I still might like to control your activities. You know what? Maybe it is for spite.
No, you'd have to show in court that you're bringing home like multiple partners or something like that,
Well,
like
what
he's
about,
bad
that
influence.
does happen.
Well, okay, wait a minute. Why? Why do I have to show sort of this, why? Why can't I just say, no, she doesn't belong overnight with my children visiting, causing further emotional trauma to them at this point in time?
I think she would argue that it's a crime already that can't be enjoined, and that, you know what I mean, that yes, we have a relationship with this new person, and, they're a good influence.
Relationship, you met 10 days ago in some bar room, okay? That person shouldn't be with my children. I don't even know who he or she is.
Well, but you're restricting yourself too.
Huh?
Then you're restricting yourself. You can't have a relationship then either.
But frankly, maybe I don't. And so I'm not saying all of this is as well motivated as you lawyers will make it. I'm saying when these go bad, they go bad, okay? And If we're going to play scorched earth, I don't want anyone else in that house.
Didn't she initiate the divorce proceedings anyway?
What?
Did she file for divorce? So isn't this her fault?
Boy, there's more lines coming out of this class than... Well, wait, actually, in Knighton, we didn't really talk about Knighton to that extent. I think she didn't file for divorce. She filed for a separate support, right? She didn't, I think Knighton didn't want to be divorced. She wanted... Huh?
He left the house.
Right, she wanted support.
She loved him.
She did. She loved the big lug, right? She wanted her man back, but she's not going to get him back, right? Well, she can't force him back. So help me with this other problem then. Can the court do that?
Do what?
Which one, the enjoyment?
I want to enjoin any overnight guests.
I think if you make that argument that it's in the best interest of the child and that it's not for spite and because you're still married and, you know, that it would be a crime, emotional distress of the children, and there's also no evidence that, you know, this relationship is of any substance at all. It could just be like any overnight guest just so that the children aren't further emotionally harmed.
So you're going
on top of the divorce.
You're going to restrict my sexual activity during the pendency of the divorce.
I can't, not the sexual activity, but
You have a right to
Huh?
Interest of children.
They can.
Yes, they do it.
They do it.
Kid's been away from his parents for almost 2 years now, and they're mental.
Yeah, that's a messed up one.
institution, and this country's got the worst mental care in the world, probably. It's horrible.
Well, I had this happen to a close friend of mine.
Yep.
And the kids are messed up. Like, you know, they see the girlfriend is the reason why they got divorced. And then they're like, they hate the woman, you know. It creates a big emotional distress during the proceeding. Oh, hi, this is my girlfriend. Oh, wait a minute. The girl that you cheated on mommy with? It does.
No, but right, I mean, it does add this additional level of, one would argue, and it wouldn't take much to get a psychologist to support this emotional trauma during pendency of during the period of a difficult emotional adjustment to begin with.
It's hard for adults, never mind children.
So could I say, forget overnight guests, I don't want him or her in the presence of my children when they're visiting with spouse. Huh?
At all?
At all. I don't want them there.
I think you have to show some bad behavior.
Well, do I have to show bad behavior?
I think that would be a harder argument to make that it's
At all.
at all is kind of like.
Well, but what about the point that Sandra just made? This is the woman that destroyed our lives, as the kids see it. Well, this is the guy that destroyed our lives. It doesn't always have to be the guy being the bad guy here.
If there's some evidence that the kid's being harmed, can't the court just say, we're going to shift custody of the kid over to the other parent?
Well, but don't you think that's the next shoe that drops here, right? I mean, I'm not just planning a little bit of a war here. I'm going to take each battle, but I'm looking for the long haul here. I mean, you're really going to fight me on overnight guests? You're going to fight me on the woman or man who broke up the marriage having to be present during social activities with your children? This is the problem that someone, we fight about this. It is fought about. And part of it is concern about the emotional trauma. Part of it is there's some hard feelings here, and I don't want that person, who I think has such poor morals, to be in the presence of my children, especially after what they've done to me, as well as my children, as they would see it. So the court could do that.
I don't think so.
They could not limit who those children, who the visitation could take place with. You couldn't structure an argument that would make, that would.
Yes, they can do that.
They can do whatever
there's
they want.
They can do whatever they want.
It's in the best interest of the children. They can do it.
Well, could you fashion the argument that it is in the best interest of the children? The situation Sandra described. They see that person as the one that destroyed life as they knew it.
You need a little more than that.
I
don't think you can win on that argument alone.
Well, but how come if the children, I mean, whether it's true or not, if the children perceive it as such? Because my argument response, at least in part, would be, if you really care about your children, and I'm telling you this is the problem with the kids, why does that person have to be present then? You've got other time during the week, right? I mean, this is the argument they would make, is they don't need to be there.
Well, you'd have to show that the children actually are affected by it and willing to vocalize
If
that.
I could testify, they tell me, oh, it's horrible. Daddy spends all his time with Lori.
Well, then you're gonna need,
Huh?
He's hearsay.
Objection, hearsay.
The child, yeah.
I don't think it's a detriment. Like, I grew up in a family like that. That was my situation growing up, and what doesn't kill you makes you stronger. I don't think you can say that's in the best interest of the child to not have that around. Like, they don't know. You can't just say, like, out of emotion, like, they don't want him there. It's not going to physically hurt them in the future or anything else. Like,
But what if, and I don't disagree that at some point, that at least the initial argument loses some of its thrust as time goes. But I think initially is where the problem is. There has to be this adjustment, and parties are going to argue this. What I'm hearing is the court has some ability to structure activities they see as in the best interest of the child. I think long-term, you're going to have to deal with all of these various issues. But there may be some period where the court has to take a more active role there. But at some point, you are overly restricting my personal activities as well, aren't you?
It comes back to what Jim says also, that if I can't do it, then you can't do it either. So it's like, no one has a life while this is happening.
Well, while the divorce is pending. At least that's the period we're talking about. There will be some that will try to, even post-divorce, will seek orders of that sort. No overnight guests, no, females in the company of my children during visitation, unrelated females. I mean, you can structure it however you want it. It does sound like there's an ability to potentially get the order from the court, but at the same point, parties want to move on with their lives. They want to at some point create a relationship between the new partner and the family, the children. So, you've got problems either way you go with it. But if at the end of the day what governs is what's in the best interest of the children.
Isn't it kind of difficult when you have like some divorces that just drag on and on and on for?
Oh yeah, that's the thing is it sounds like it's relatively temporary. Well, it is. It depends on how you guys describe temporary, because a complicated, expensive divorce, with assets and significant custody issues, you could be looking at 3 or 4 years, easy.
What about a right to procreate? Say it's a girl, she wants to have more kids. She'd be like, what if I want to have sleep?
Say she's
I
a
want
woman?
more children. Well, instead of a guy, it's a girl, and the guy's trying to enjoin her of having any female company over his house, and she says, well, I want to procreate. It's my right. They're gonna say do it on your off weekends.
Yeah, right. Yeah. So why not? Is that's going to be your defense? I want to procreate when the kids are there. I think you might want to structure a better argument. Might be the fallback. I'm not so sure it's my lead argument.
Wouldn't the court order counseling for the children and, see how maybe the whole group?
Well, I would expect that the court in a situation like this where and a lot of them, too many of them get like this, just so you understand. This is not a law school discussion. I've sought and obtained such orders. Others have sought them as well against clients. That's the nature of it, especially early on in the process, because feelings are so raw. And what they're likely to do is appoint a guardian, and then the guardian would report to the court after talking to the child and seeing what the household situation is and the like. And go ahead.
What about mediation? Would they?
Well, even within the probate court, you have the probation officers who will often try and mediate the process, and there are mediators within the courthouse. The problem is, what I'm envisioning is not a situation where people are not going to be reasonable about it, but really are taking the alternative approach, which happens too often, which is let's take a scorched earth approach to this and argue about absolutely everything. And to some extent, I mean, this it's not all, it sounds like I'm overly cynical that it's all illegitimate. I think some of it is well motivated. I know my kids are having trouble dealing with this. I don't want, it's the point that Sandra made. So now we have strangers who are somehow getting involved in dictating to me or my children what they can or can't do, what I can and can't do, and that's where these additional levels of problems come in. And that's why the probate court has some authority, not some, it has extensive authority over it to regulate that activity. This is what I found early on in practicing, and it's in probate court especially, but virtually any court. You can bring a motion for anything, okay? I've been in court, handwritten a motion sometimes, saying, you know what, I'm going to see if I can get this to go, right? If you don't ask, you don't get anything. But the fact is, you can bring a motion to ask for virtually anything. And the fact is, if you can support it, at least in the probate court, we see that there's some significant latitude there. And the fact is, you've got to think about, you may be able to win that battle, but what does that do ultimately for your case? I mean, okay, so does that somehow, we're saying, well, it's her fault she brought the divorce, or other items here. Is that going to affect the court's thinking on custody ultimately? If I'm really willing to fight for a boyfriend I've known 2 weeks over children that I'm supposed to have their best interests at heart here, that may be something that you need to think about. How does this affect potentially the long-range thinking here? Even if the court says, no, I'm not going to grant you such an order, it may be problematic with respect to how that ultimately weighs out in the court's thinking about, is it 3 days, is it 2 days visitation, is it, how does the custody arrangement going to work? And the problem is, in a lot of these situations like this, where we're fighting about everything, joint custody, physical and legal, it may be impossible at the end of the day, simply because the parties are going to go to war on everything. And again, it makes more sense to me, never having been divorced, that parties would talk to each other as opposed to spending the ridiculous amounts of money people spend on lawyers. I'm also told, because my wife works in the probate court, about half the litigants these days do not have and cannot afford lawyers in the probate courts. And that's not a good thing necessarily, because pro se litigants can be completely off the wall and irrational and unreasonable. The cases I've had where they were representing themselves, and most lawyers would tell you this, they're far worse, simply because they've got no limits, and they don't understand the process or the limitations, and you might as well be talking to a rock sometimes to try and convey information that would be reasonable that most people would listen to. And so that's not necessarily a healthy thing either. Let's look at Edgar, which is the contempt case, and I think this is the ultimate sanction that the court has the authority to do. Any order of the court, by way of an injunction, by way of child support, is enforceable through a contempt process. And contempts can be either civil or criminal in the probate court. It's generally civil if the court is trying to coerce compliance. It would generally be criminal if the court is intending to punish the behavior. And so part of it, you need to know, if you're facing contempt or if you're seeking a contempt charge, what exactly are you looking for here? Do you want to get enforcement of the order? Are you looking to have the orders complied with by the court? Are you looking to punish? And if it in fact is a criminal contempt, then obviously the additional criminal safeguards are present, including the higher burden of proof and potentially the right to counsel. Because if your liberty interest is at stake, in a criminal contempt, you have those additional protections. This is a case where the court, and the jury trial as well in a criminal case, depending on the potential sentence. They're divorced. The agreement requires the defendant to pay $200 a week for support of his minor children. He failed to pay as agreed. A new complaint for contempt was brought. They appeared at a hearing on March 5th, '87. He filed a motion to vacate the judgment of civil contempt entered earlier. The judge then said, I'm going to conduct a hearing on the complaint and treat it as criminal contempt. He advised counsel for the defendant would be incarcerated if he were found guilty. 2 hours later, the hearing commenced, so didn't comply, obviously, despite the court's pretty harsh threat. At that point, the hearing was continued, a week. Again, I think done in part to try and scare and coerce the defendant. It didn't change. At that point, the court finds him guilty and sentences him to imprisonment for 30 days. On a contempt, the court can, in fact, force compliance or simply vindicate the court's authority and incarcerate you. Even though, obviously, this case starts out as a civil case, the contempt can be either civil or criminal. Here, the defendant, and you need to look at now, we're trying to say, well, does he get a jury? Does he get the criminal protections? And how does this work here? He knew, he was given sufficient notice that the court was going forward with a criminal contempt action, even on relatively short notice like this, but he had the complaint before. There is no constitutional right to a jury trial in a criminal contempt proceeding in which the penalty is 6 months imprisonment or less. So he might like a jury, but if the court is not inclined to sentence you to imprison for more than 6 months, then you don't get a right to a jury trial either. And so he's out on that account. The other part of it is, with respect to the jury trial, is the note 1 here. There's nothing in the record to indicate the defendant ever requested a jury trial. That's on you, right? If you're the lawyer, you can't raise items on appeal that you don't first try to get the trial court to address. And so if you want a jury trial, you've got to ask for it at the time. Having not asked for it, the appeals court is almost never going to listen to you. And here, they don't have to, where the imprisonment is potentially, in which the penalty is 6 months or less. So he's out on both accounts. But I want you to take a look at that footnote 1, because we see it in evidence, we see it in procedural issues like this. If you want something, you've got to ask. And if you don't ask, don't think that you're going to come up with a clever argument on appeal, because they're always going to dump it back on your shoulders. It works the same way with evidence. If you think evidence is objectionable, you got to object and you got to hold your ground. Same type of thing on procedural issues. If you do not, then the likelihood is you're going to be out. And so the court, for 2 reasons, dumps it back on the lawyer's lap. The court has no problem finding that he got sufficient notice, relatively limited, but he got sufficient notice that the court was going to treat this as criminal contempt, and in fact they did. The next part of the case is the point about damages on a contempt action. If you're in contempt, not only do you owe whatever it is that the plaintiff has lost as a result of your contempt, but now you owe attorney's fees as well. And so oftentimes in probate court, parties do initiate and not just probate court, by the way, contempt also governs violations of injunctive relief. So if it's the Superior Court, you would also bring complaints for contempt because an injunction has been violated. But again, in the probate court or in the Superior Court, you need the order to be clear, because in order to show a violation, you have to show that the person knew what the order was capable of complying with the order, and didn't. It's a relatively simple process, but you need to show all three things. And so if, in fact, the order is ambiguous or unclear, and that it's an order you likely wrote if it's an injunction. If it's an order for support, as this one was, it's relatively clear here what his obligation for support was for these children. And so therefore, he was in contempt. He did have the ability to comply, and the court was able to sentence him under those circumstances for contempt. On the appeal, now they want counsel fees. Not just counsel fees for the trial court, the probate court, but they want counsel fees on the appeal, which you're entitled to as a general matter under the appellate rules as well. And the fact is, on a contempt matter, if in fact the party's in contempt, as part of your damages, you're entitled to the cost of having to seek the contempt, which means that you're entitled to petition the court for attorney's fees as part of your relief. And in fact, the court issues the attorney's fees as well as part of the relief in this case. The last things you've got here, actually you've got Goodrich as well, which is one of the early, the Massachusetts case on same-gender marriage, Goodrich versus Mass Department of Public Health. And this was a 2003 case that, to some extent, snowballed the change. Is written by Justice Marshall, and talks about that the constitutional right to marry, just because tradition previously defined it as between a man and a woman, doesn't mean that it has to be perpetually defined that way. And so the last articles we have here are, the breaking up is hard to do, and the push for parent education. Those of you that are interested in family law, and I don't understand why we probably don't do more of it if you're going to do it this way, but we're not counselors necessarily. But I think some of you have already suggested we ought to encourage people to use the mediation, to use the other processes the court has. The fact is, I think there's some good suggestions in here with respect to how to start to think about practicing in this area and all the pitfalls that are potentially available. I think in part, and I don't know, I've never figured out a way around this. I think some parties, the emotions are so raw that they turn to the probate court and just need to vent some of that for a while. It's unfortunate, though, because it's a very expensive process to use as sort of a platform to vent and for retribution, where the fact is that money would be better spent on the kids, on counseling, on any other service other than us, because so you hire a lawyer and I hire a lawyer and the lawyers go in and fight, and there will be times where they fight about everything, where experienced lawyers have a pretty good understanding as to what likely will be the outcome of the case with respect to both support, visitation, custody, and there's a lot of things that would go into that about the tax implications as to how it could work, and structuring that you'd be better off with some experts assisting you, and probably that money would be better spent on counseling. Because I think it's, for many people, it's the hardest thing that they face. And our process, as I see it, doesn't always, is not always the best process. It'll ultimately get the job done. But I've seen divorces where we've spent well over $100,000 to try and distribute the assets and and resolve the custody issues. And for the next 10 years, people are still at war. It seems like a waste of resources. It's good money for you guys. You have to have a thick skin and like to do it, because there are times where it can be emotionally draining, because when you get that call, you'll never guess what he did now. You really feel like saying, I could give a flying what he did now. You really want to spend $300 on this call? But so at some point you say, I can't do it anymore.
When you talk about counseling, are you referring marriage counseling or just
I'm assuming the marriage is over. I'm assuming counseling to deal with the issues going forward with the children, because seriously, it's you guys wouldn't everyone wouldn't give that poor kid summer camp. It's summer camp. It's private school. It is the ballet lessons. It's you name it. And obviously it makes more sense for you folks to work this out and to let the anger and hostility go. But that's easier. That's easy to say if you weren't one of the parties who feel was wronged by it. So, by the time I usually got them, it was over. It was way over. So
Is that always the case?
Huh?
Is that always the case?
No, you know what? I'll be honest with you. Someone called me, probably spoke to him about 18 months ago. He wanted a referral before. My wife worked in the probate court, and so I talked to her, and we got the name of both a lawyer and a counselor, and he called me 18 months ago to say he really appreciated the help, that they got back to counseling and things were good for them. So they ended up not doing it. To me, it seems it's rarer. By the time it gets to that point, in my experience, and my experience has, for the most part, I handled contentious litigation and divorce. So by the time they were long since gone, and there were a lot of stuff to fight about, and they would fight about a lot. So that's for the most part. But that occasionally has happened. But honest to God, and I haven't done it in probably 20 years. But I used to do, when I was in Boston. I was in Boston for the first 6 years of my practice. I did maybe about 20% of the litigation I did was in divorce litigation, and it never happened. I even had one that we tried. It was horrible case. They hated each other, hated each other, and it was ridiculously contentious. And he then, a couple years after we tried it, they obviously were apart, divorced. He's driving down Storrow Drive late at night, goes off Storrow Drive into the Charles River, dies. He never changed any of his insurance benefits. He never changed any of his retirement benefits. She got all of that too. It was odd because they hated each other. I think it was just a complete oversight. So strange things happen. Go ahead.
The reason I mention that is because we had family court. They go to foreign probate court and do that. Anyways, one of the students I was with was actually in a firm. I think it was in Medford, and he was talking about his experience. And he said that, well, these people come in, and basically they just sign them up. And I said to him, well, don't you ever think of maybe encouraging marriage counseling to do something, maybe find some type of mediation before you go into it? He looked at me and said, no, we don't do that. And I'm thinking to myself, wouldn't that be a good precursor? And instead of just bringing them in and say, okay, let's go, use a retainer.
Yeah, no, with that regard, I had someone... No, he's saying they're seeking advice. I've had people come in for advice like that, advice, what are my options? And that, we'd talk about that. I had someone come in, she used to come in like every 3 or 4 months, had been married more than 30 years. I think maybe this time I'm going to do it. I said, what the hell, why at this point? But so you'd suggest to her, because I don't, She ultimately filed, but by the time she filed, I think they were married 34, 35 years.
Did he know about it?
Huh?
Did he know?
Well, that's her first, she used to start with that. I want to file for divorce. I don't want him to ever know. That's not the way it works. She's an interesting client.
I remember Professor Goldman told me the thing when he does the mediation there. It was just funny. He's like, I remember going to a girl and she was fighting for this big TV.
What are we going to do with him?
And I didn't say it. I'm just relaying a quote.
Oh, yeah, Fred Goldman said girl. You're right, Mark.
Did not say girl.
Okay, female. I don't even want to say.
Woman.
There was a person who wanted a TV and fighting for the TV, and he finally said, why do you want the TV? And this person said, because the other person wants it.
Oh, sure.
You know what I mean? They don't even watch it or use it.
Called the pots and pans divorce. We're going to argue about everything. And so I think more counseling would be better, but I'm not so sure. We can advise it, we can counsel for it. And in fact, especially early on, people should understand that the process, if they're coming in like that thinking, well, this is a quick solution, it is not a quick solution to any of it. And so a lot of times you will say, what have you tried? Have you tried to do anything? Or he won't go, she won't go, we're done. Usually, by the time they hit the lawyer's office, they've talked to enough people that the likelihood is that it's going to go forward. So I'll see you guys next time.